If you may please the court, Your Honor. This case is about public trust. As we said in the opening statement, it's clear, it's straightforward, it's concise. It boils down to what the defendants wrote on paper in black and white versus what's on video. It's a paper case. The evidence proves beyond a reasonable doubt that defendants Gaffney, Walsh, and March each filed false police reports, thereby committing official misconduct and obstruction of justice. And they participated in a conspiracy to commit those same crimes. Rule number 1, obey the law. That's what police officers learn through their rules and regulations. First and foremost, obey the law. Don't do things you arrest people for doing. Lying, cheating, falsifying, violating the law. Don't make false police reports. Tell the truth in police reports. Report crime, unlawful actions, violations, improper conduct. Don't ignore or fail to report misconduct. Don't disseminate or release CPD records concerning police matters. Restrict access to information to official police business. Prohibit access to information for personal or other reasons. You saw those rules that were admitted into evidence. Beyond these CPD rules, the law also requires that defendants who are sworn, these defendants who are sworn police officers, obey the city municipal code, the Illinois criminal code, and the Constitution. These are very basic concepts. There's nothing complex. Intentionally filing a false police report is a violation of the public trust. It's a violation of their oath of office. And as is most relevant to this court, it is official misconduct. On the night of October 20th, 2014, Officer McGilligan did the right thing. Good police work. Defendant Gaffney also did good police work that night until he joined with defendants Walsh and March and others to try to protect Jason Van Dyke by creating a false justification for Van Dyke to have shot and killed Laquan McDonald. You heard the evidence in this case, Judge. Officer McGilligan and Officer Gaffney responded to a call from a citizen who held a man. They didn't know much else. They arrive on the scene. They see a man. He's hiding in the bushes. Officer McGilligan gets out of his car. He asks the man to show his hand. He shows his hand, and in his right hand, there's a knife. He says to his partner, he's got a knife. Defendant Gaffney calls it in to dispatch. This guy's kind of walking away from us. He's got a knife in his hand. His voice is calm. His actions are calm. He's appropriate. The dispatcher then calls for a taser. Laquan McDonald starts walking away. Officer McGilligan stays out of his car with his gun drawn and a flashlight. You saw Greater Chicago Food Depository 1 and 2. They were walking. Nothing unusual. Officer McGilligan has his flashlight. He's got his gun drawn. He testified. Officer Gaffney is in the car. He's driving alongside. They're walking. Laquan didn't say anything, but he didn't drop the knife. He just kept walking. They walked 4 or so blocks. Officer McGilligan testified. He didn't feel at any time during the encounter with Laquan that he threatened to use deadly force. Officer McGilligan was with Laquan. He was within 10 to 15 feet, he testified. Sometimes Laquan would turn around, he would look at him, but he would walk backwards. Sometimes he just kept walking. He never said anything, but he wouldn't drop the knife. Still, Officer McGilligan never felt that Laquan made a threatening move. He was out of his car. He had his gun drawn. He was watching when Laquan popped the tire and scratched the windshield. Yet he still didn't feel that his partner, defendant Gaffney, was in danger of serious bodily injury. McGilligan testified he didn't shoot or grab Laquan. He didn't slide off the car. Laquan just slid off the car and he fled. He ran away. Officer McGilligan testified that he then put his gun back in the holster in order to give chase. In order for Laquan to pop the tire and scratch the windshield, defendant Gaffney turned the car in Laquan's direction. When he turned the car in Laquan's direction, he also testified to a grand jury that he didn't feel in danger of death or serious bodily injury, even after Laquan scratched the windshield, popped the tire of the car. He had his car to protect him. That was his testimony. That was what his partner testified to. Officer McGilligan testified consistent with defendant Gaffney's sworn testimony. So let's talk about defendant Gaffney's TRR, the Tactical Response Report. You heard testimony from Sergeant Snelling that a tactical response report is used when an officer uses force. And it's to tell what they did and why they did it so that they can explain or justify what their actions were. Sergeant Snelling also testified that if an officer is assaulted or battered, then they also fill out an OBR, an officer battery report. In order to get to the officer battery report, you have to go through the TRR. So let's look at this situation here. Officer Gaffney is in his car. He never gets out. He never engages with Laquan McDonald except for turning his car in front of Laquan. And Laquan pops the tire, scratches the windshield. So he never should have completed a tactical response report. He had no reason. He wasn't assaulted. He wasn't battered. Defendant Gaffney didn't use any force, and therefore there's nothing to report. But he did complete a TRR, and you have to ask yourself, why? Well, the evidence is clear that he did so that he could lend his voice to the choir that was singing for justification for the killing of Laquan McDonald. He was trying to help protect Jason Van Dyke. But let's assume for a moment, just assume, that the rules are different and it's okay for him to complete a TRR. What does that TRR say? It says he's a passive resistor, didn't follow verbal direction. That's the first box. It says he's an active resistor, fled. Why does it say that? Because both defendant Gaffney and his partner McGilligan say Laquan kept walking away and eventually he ran from us. So it should say he fled. It shouldn't say that he was an assailant assault, imminent threat of battery, because defendant Gaffney swears under oath that he was not in fear of death or serious bodily injury because he was protected by the car. It might even say that he popped the tire or scratched the windshield, but it doesn't say that. Where is that? It would not say assailant battery because Laquan McDonald never touched defendant Gaffney. Gaffney stayed inside the car. Critically, Judge, and this is where Officer Gaffney's intent becomes clear. It would not say in the last box, assailant deadly force uses force likely to cause death or great bodily harm weapon. Because as we've discussed, Gaffney testified before the grand jury that he was not at risk of death or serious bodily injury from Laquan. The TRR is false. Why did he check that box? Uses force likely to cause death or great bodily harm when he already testified it didn't happen. He told you it didn't happen. Why would he lie? Sergeant Snelling explains to you why. He testified, Sergeant Snelling did, that the only way the shooting of Laquan McDonald could be justified is if that last box is checked. That's what makes it clear why Daphne lied. The only time that an officer is justified in using deadly force is if that box is checked. Defendant Gaffney and Van Dyke and Walsh checked that box, knowing it was a lie, but also knowing that it was the only way to make the killing of Laquan McDonald seem like a justifiable homicide. That's official misconduct, that's obstruction of justice, that's conspiracy. Right there in black and white, right there on paper. Let's talk about defendant Walsh. He also filed a TRR that is patently false. And as you've seen and heard of the evidence and testimony, defendant Walsh checks the exact same box as defendant Gaffney. Defendant Gaffney and defendant Walsh were nowhere near each other when they both encountered Laquan McDonald. So officers who encounter Laquan McDonald in two completely different locations have two completely different experiences with him at two completely different times, yet somehow they fill out the exact same TRRs. That's powerful evidence of conspiracy and the criminal intent. Judge, you've seen People's Exhibit 813R dash cams, which is the video of Laquan McDonald walking down the street, walking down 41st and Pulaski. It also shows defendant Walsh and his partner Jason Van Dyke as they arrive near 41st and Pulaski. This is where Laquan McDonald went after he fled from defendant Gaffney and officer McGilligan. The dash cam shows Walsh and Van Dyke slow down their car just as they go past Laquan. They move around another squad car and then park at an angle just past Laquan. The video shows Van Dyke as he gets out of the passenger side of the car and immediately points a gun at Laquan. It takes several steps in the direction of Laquan McDonald. He's walking down the street, Laquan is. This officer gets out of his car and takes steps in his direction. His partner, defendant Walsh, gets out of the passenger side of the car and goes around the back of the car and does the same thing. He approaches Laquan McDonald. This is not the action of a person who believes they are in danger of a battery. Sergeant Snelling also testified, and he told you how officers are trained. He told you that they are trained to keep a safe distance. They are trained to shield. Officer Walsh didn't hide behind the car. He walked toward Laquan McDonald with his gun drawn. Why? Because he didn't believe he was about to be battered. Neither defendant Walsh nor Van Dyke backpedaled. The video is clear. They don't try to keep a safe distance. They go closer to Laquan McDonald. In the video, defendant Walsh actually appears surprised as his partner Van Dyke suddenly fires his gun. He puts an extraordinary number of bullets into the body of Laquan McDonald. The video actually shows him flinch as McDonald is shot. McDonald's body turns and then it falls to the ground, and you heard witnesses say they saw him twitch while he was on the ground, as the additional bullets are then being shot by Van Dyke. There is nothing shown in the video that indicates that McDonald made any movement as if attacking either Van Dyke or defendant Walsh. The video is irrefutable that Laquan is walking in the direction that would take him farther away from defendant Walsh and Van Dyke. He starts in the middle of the street. The video is clear. He's walking south. He crosses west over the yellow line, and he's then into the lane on the opposite side of the street toward the empty, unpopulated construction area. The video is clear. Laquan did nothing that could be considered threatening imminent death or great bodily harm to either defendant Walsh or Van Dyke. But of course, that is the only action, the only box that justifies Van Dyke's shooting. That box, threatening imminent death or great bodily harm. The video shows defendant Walsh didn't use any force that would require him to explain his actions on a TRR. He didn't shoot Laquan, he didn't struggle with him, he didn't fight with him, he didn't subdue him. The video shows clearly that all he did was point his gun, take steps in his direction, and then flinch when Van Dyke fired the first of the 16 shots. He wasn't assaulted, it's not even close. So he shouldn't have filled out a TRR, not even to get to the OBR. But like defendant Gaffney, he filled out the TRR and he put in false information. He checked the box that said Laquan was a passive resistor. That box was correct. But like Gaffney, he didn't check the box that said Laquan fled, even though the evidence judges that Laquan is walking as if he's trying to get away from the police. Defendant Walsh also checked the box indicating assailant assault, imminent threat of battery, assailant battery, even though the evidence is 100% clear there was no battery. He also checked assailant deadly force, uses force likely to cause death or great bodily harm, weapon. That, judge, is the critical lie because that justifies Van Dyke's use of deadly force. There was no reason to use deadly force. Walsh did not use deadly force. Checking that box was a lie, and it was a clear attempt to paint a picture that protected Van Dyke. The video evidence is irrefutable that defendant Walsh was on the scene for 6 seconds before Van Dyke shot Laquan. And that entire time, Laquan is walking west, south, away from the direction in which defendant Walsh stopped the car. As defendant Walsh gets closer to Laquan with his gun drawn on that human being who had a knife. Defendant Walsh could not have been in reasonable fear of an imminent battery. But again, let's assume that the rules are different and that defendant Walsh, for some reason, should have completed the TRR. What should it have said? Defendant Walsh's TRR would have said, like Sergeant Snelling indicated, passive resistor did not follow verbal direction, active resistor fled, and possibly other deadly weapon, knife. Instead, defendant Walsh wrote the identical information given by defendant Gaffney and Van Dyke. That is false. That's official misconduct. That's obstruction of justice. That's conspiracy, right there in black and white. So let's talk briefly about the officer battery reports. Defendants Gaffney and Walsh both filed officer battery reports. They were also false. Sergeant Snelling testified that those forms are used, of course, when you're assaulted or battered. And they are from the officer's perspective, not from another officer's perspective. So it's the individual who's completing the form, and there's no ambiguity. And as we've shown, defendant Gaffney nor defendant Walsh was assaulted or battered. So they have no reason to complete the OBR. But again, let's assume the evidence is different and they each reasonably believe that they were assaulted. Well, what would that OBR look like? Well, defendant Gaffney encounters Laquan McDonald at a different place. So his OBR should say, pop the tire, scratch the windshield. Maybe it would say, I'm afraid or I'm assaulted. But it's not going to say 3 officers battered, which it does say, because there aren't even 3 officers on the scene. It's just he and McGilligan. So where does the 3rd officer come from at the location where Laquan McDonald encounters Officer Gaffney? How does he complete an OBR that says 3 officers battered? The manner of attack he puts in, stabbed, cut, including actual attempt, type of weapon, other, swinging knife. He didn't write pop the tire. He didn't write scratch the windshield. He wrote swinging knife. Why? So his narrative could be identical to defendant Walsh and Van Dyke. So that there could be 3 officers who would have said the exact same thing. It was all false, but there's strength in numbers. This is official misconduct. This is obstruction of justice. This is conspiracy. Defendant Walsh also filed an OBR that's false. Again, he does the same thing that defendant Gaffney did. He writes 3 officers. Well, defendant Walsh is not in the same location as defendant Gaffney. So how does he even write 3 officers are battered? How does he even know? He gets out of his car at a totally different place, at a totally different time. He also writes swinging knife, just like Gaffney and Van Dyke did. Exact same words. It's official misconduct. It's obstruction of justice. It's a conspiracy. How do you get 3 identical TRRs and 3 identical OBRs from 3 officers who had 3 different vantage points? Judge, at some point, the officers on the scene, including the shooter in the case, Van Dyke, were directed to Area Central at 51st and Wentworth for further questioning. McGilligan testified that when he arrived, he saw several detectives, Van Dyke and defendant Walsh, watching the Dunkin' Donuts video. They were discussing positioning of where they were when Van Dyke shot. He heard someone say that defendant Walsh backpedaled, clearly discussing the facts of the incident that had just occurred, interpreting the video in a room together, trying to get justification for a shooting that just occurred. Officer Fontaine also testified that when she arrived at Area Central, defendant March asked her, "Come with me into a small office," where there was a computer playing the dash cam video, which is dash cam video 813R. He played that video for her and then narrated the events. You heard her testify. He said to her where McDonald's walking, where he's turning. She agrees. She leaves. He never asked her questions. He didn't ask her to explain. He wasn't taking notes. Defendant Gaffney, and Judge, this part is only offered for defendant Gaffney and no one else. But he admitted in his grand jury testimony that everybody was in a room talking. Detectives were there, but I'm not sure if they were actually doing like notes, interview notes. They were just going over everything. We were all in the same room, just talking what happened. All the officers that were involved that were on the scene. That's in evidence, Judge. That's how you get 3 identical TRRs, 3 identical OBRs from 3 officers who had 3 different vantage points. Official misconduct, obstruction of justice, conspiracy. Let's talk a little bit about defendant March. Van Dyke put 16 bullets into the body of Laquan McDonald. Defendant March, who was an area central detective, star number 20563, was assigned to investigate the shooting. The question that the police had to answer that night was the killing of Laquan McDonald justified? According to defendant March's report, which is People's Exhibit March Case Sub 2, March arrives on the scene. He locates and interviews the shooting officer, which was Van Dyke. He also interviewed other officers on the scene. He interviewed defendants Gaffney and Walsh, Officer McGilligan, Officer Fontaine, other folks who were on the scene. He did ensure that collection of the video evidence was maintained. He did process the scene. He did give Dora Fontaine, direction on what to put in the case report. She testified. She was on paper, and she testified that what paper meant is that she was assigned to collect the names and star numbers and fill out the paperwork. And she also testified that it was Detective March who was telling her what to put on that paperwork. And just as the reports in the detective file show, Sergeant Lance Beckbar collected the dash cam video. There's evidence that officers were watching those recordings in the Dunkin' Donuts. Officer McGilligan testified as much. Officer Fontaine testified as much. There were cars on the scene. There were businesses with cameras. No one knew instantaneously which dash cam captured the shooting or whether there were videos of what happened. Other than getting that dash cam right away, the only thing he could do was collect all of the evidence. But what Detective March did in his police report is he characterized the video. That was so that no one would need to watch the video. He characterized them as consistent with all of the officer's statements that he detailed in his report. But those statements in his report contained assertions that are indisputably false and that are designed to provide a justification for Van Dyke having put 16 bullets into the body of that teenager with a 3-inch knife. You've seen and heard those statements, Judge. Raised right arm as if attacking, raised knife over shoulder, attempting to get up, trying to kill police officers. You've heard that Dora and her partner, Viramontes, were assigned. You've heard that it was Defendant March who told her, categorize it as an assault aggravated PO knife/cut instrument. He told her, list the victims as defendants Gaffney, Walsh, and Van Dyke. It's a homicide or it's a killing of Laquan McDonald. Why isn't he the victim? He told her, write that Van Dyke was injured by offender. Didn't happen. He told her to write, refer to Detective Division Supplementary. Defendant March had her write down information that was false. That's official misconduct. That's obstruction of justice. That's conspiracy in black and white. At 11:51 that night, Defendant March even started off when he called the Cook County Medical Examiner's office and spoke with the investigator Earl Briggs. He gave him his name and his star number. Detective March, star number 20563, Area Central. During that call with Briggs, Detective March told him the subject lunged at the officers with a knife. That's false. Mr. Briggs told you. He was certain that's what was said. He repeated it back. Detective March did not correct it. Earl Briggs had no reason to lie about what March told him. He was unequivocal that Detective March told him Laquan McDonald lunged at officers. That's powerful evidence that Detective March lied about what happened on the street in order to justify the shooting. Within hours of being assigned to the shooting, he's shaping a false narrative. A little over a week after the shooting, Judge, Defendant March wrote a report, People's Exhibit March Case Incident 1. In that report, he indicated, and I quote, McDonald committed aggravated assaults against 3 officers, Walsh, Gaffney, and Van Dyke, finally forcing Officer Van Dyke, in defense of his life, to shoot and kill Laquan. Details of the investigation are reported under homicide justifiable. Finally forcing. He makes it sound as though Laquan McDonald is doing something that forces Officer Van Dyke to shoot. This characterization of the incident is false. Van Dyke is not shown on the video being forced to shoot in defense of his life. To the contrary, he's shown getting out of his car, taking steps toward Laquan, and then shooting within seconds of having gotten out of the car. Laquan, on the other hand, is shown walking away with a knife directly before he's shot. No officers are assaulted. No officers are battered. Mr. Safer took you through all the false statements in Defendant March's report during our argument in defense of the motion for directed finding, Judge, and so I won't repeat those. I would ask, because it's a bench trial, if you would take notice of those.
Are you asking to adopt that?
Yes, I am, Judge. I'm asking to adopt our statement, the entire argument.
Okay.
They are clear. They are official misconduct, obstruction of justice. Almost 6 months later, in March of 2015, defendant Sergeant Dan Gallagher and Lieutenant Tony Walsh then file a supplemental case report, March Case Incident 1 and Fontaine Case Incident 1. As the detective file, the general progress reports, and CPD email 1 show, Judge, Sergeant Dan Gallagher received his information about defendant March's investigation from March. Tony Walsh received his information from Gallagher in March. That's the command structure. That's how the reports are approved and submitted. But let's talk for a moment about the emails, because the emails help make the scheme crystal clear. And Judge, we understand and admit that there's only one, and I believe counsel admitted a second email that are to Detective March and not the other defendants. We acknowledge that. We also acknowledge that the emails post-date Walsh and Gaffney's submission of their reports, but they're important nonetheless because they make explicit in black and white what the defendant's conduct makes very clear. There was a conspiracy to have Van Dyke avoid prosecution. The conspiracy started on the night of the shooting, but it continued long after. In CPD email 1, Sergeant Gallagher, who was March's sergeant and a co-author of the case sub report, emails from his personal email to Lieutenant Wilson, who March's lieutenant, and another co-author of the case sub reports, the false information for justification. That said, we should be applauding him, speaking about Van Dyke, not second guessing him. It concludes objective reasonableness. Would a reasonable officer placed in a similar situation take the same action? The answer is absolutely. CPD email 4 and 5 show that around the same time, case supplementary reports are submitted and approved in early 2015. Lieutenant Wolsick and Sergeant Gallagher are emailing around a police shooting article and other information from Mr. Ron Hosko, who's the president of the Law Enforcement Legal Defense Fund. The article is about a police officer's reaction time to start and stop a shooting. This is a critical point because Van Dyke had emptied his entire clip of 16 bullets into Laquan McDonald and then reloaded. After he approves the case sub report, Lieutenant Wolsick emails back to Ron Hosko, "Thanks again for all." In CPD email 2, Lieutenant Wolsick writes the conclusion for the case supplementary report to justify the shooting and sends that conclusion to defendant March. It says, quote, "The above to-date investigation determined that Jaquan McDonald was an active assailant who threatened the imminent use of force likely to cause death or serious injury when he incised the tire and stabbed the windshield of a CPD vehicle occupied by Officer Thomas Gaffney, and initiated imminent use force likely to cause death or serious injury when he initiated an attack on Officers Jason Van Dyke and Joseph Walsh. The above investigation concluded Officer Jason Van Dyke's use of deadly force, the discharging of his duty firearm, was within the bounds of the Chicago Police Department's use of force guidelines and in conformity with local ordinance and state law." That characterization is false, right there in black and white. Laquan was not an active assailant. He didn't threaten the use of imminent force likely to cause death or serious injury to defendant Gaffney. He didn't attack or initiate an attack on Van Dyke or defendant Walsh, and he did not use imminent force likely to cause death or serious injury against Van Dyke or defendant Walsh. So why did Lieutenant Wolsick write that conclusion? Well, using false information from defendant March and Sergeant Gallagher, he wrote the report as the last sentence of that report makes clear, to help justify using deadly force on an individual who did not pose an imminent threat of death or great bodily harm to these officers or anyone else. In March Case Sub 2, which is another case supplementary report that clears and closes the case, Defendant March writes that same conclusion to justify the shooting. He writes that the above-to-date investigation determined that Laquan McDonald was an active assailant who threatened the imminent use of force likely to cause death or serious injury when he incised the tire and stabbed the windshield of a Chicago Police Department vehicle occupied by Officer Thomas Gaffney and initiated imminent use of force likely to cause death or serious injury when he initiated an attack on Officers Jason Van Dyke and Joseph Walsh. The same false information, the same false conclusion, the same false justification for that case, right there in black and white. In that supplementary report, Defendant March also writes that the recovered in-car camera video from beats 845 and 813R was viewed and found to be consistent with the accounts of all of the witnesses. He knew that was false, as does any objective viewer of that video. Again, Mr. Safer went through some of those false statements, Judge. You've heard the evidence. I won't repeat it. Defendant March says in People's Exhibit March Case Sub 2 that McDonald committed aggravated assault against 4 officers: Van Dyke, Walsh, Gaffney, and now he's added McGilligan. We know that's false. McGilligan testified that he was not assaulted. As I discussed before, Van Dyke, Walsh, and Gaffney were not assaulted either. Defendant March falsely included McGilligan as a victim in order to support justification for the killing of Laquan McDonald. That's not supported by the video. Mr. Safer also discussed Dora Fontaine's testimony, the indignities that she suffered, and the import of her testimony. Defendant March lied about the critical aspect of how she described what she saw. When she learned that he had attributed a statement to her that she did not say in December 2015, she was furious and called her lawyer. She told this court, "I did not say that." She had no reason to come in and lie. Violating public trust, official misconduct, obstruction of justice, proved beyond a reasonable doubt, right in black and white. And as if that's not enough, Judge, any luck making the case go away? Well, Judge, we're here because these officers and others tried to make the case against Van Dyke go away. Laquan McDonald was a human being. He deserved due process and the law, and not to have police officers write false reports and shape a false narrative to justify his killing. Filing a false police report in order to protect a fellow officer from prosecution is not honorable. It's not sticking up for a colleague. It's a violation of the public trust. It's a violation of their oath of office. It's a violation of the law. It's obstruction of justice. And agreeing together to violate the law in this way and taking an act in furtherance of that agreement is conspiracy. We wholeheartedly agree that being a police officer is a dangerous job. It's public service at its highest. We have the utmost respect for the thousands of police officers who serve and protect all of the people in this city. But along with that authority to serve and protect comes the responsibility as sworn officers to respect the law for all citizens. They are sworn to enforce the law for all citizens. They are not above the law. There's no police officer exception in any of the laws that these officers violated. Our justice system is built on police officers following the law. Our system only works when police officers follow the law. The proof beyond a reasonable doubt has been presented to you, Judge, in black and white, on paper and video, and live testimony. Defendants Walsh, Gaffney, and March are each guilty beyond a reasonable doubt of the crimes of obstruction of justice, official misconduct, and conspiracy to commit those crimes. They should be held accountable for their actions. This court should find them guilty beyond a reasonable doubt based on the evidence presented. Thank you.
Thank you.